Hello, bonjour. Good afternoon, everybody. My name is Eric Chapuis, Business Advisor at the World Trade Centre Winnipeg. I would like to begin by respectfully acknowledging that this webinar is coming to you from Treaty 1 territory, traditional territory of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene people, and on the national homeland of the Red River Métis. Thank you again for joining How to Protect Your Intellectual Property and Explore Funding Opportunities, which will be presented by Sylvia De Sousa. A few housekeeping information before we start. Please send all webinar questions directly through the chat box at the top of your screen, and Sylvia will try her best to answer as many questions as possible toward the end of the session. For all logistical questions, please send directly to the chat box and I will answer your question as soon as possible. You will also receive the recording and the slides at the end of the presentation or within the next week. All right, let's kick off this webinar. I would like to introduce you to Sylvia, partner at TDS, with a practice that is concentrated in the area of business law and emphasizes on intellectual property, law, and technology law. Her practices also includes intellectual property transaction, cannabis advertising and marketing, intellectual property protection, trademark, copyrights, patents, and licensing matters. Sylvia is a trademark agent. Sylvia has spoken on many occasions to professional organizations and industry groups on intellectual property matters and technology law matters. All right, well, welcome Sylvia, and let's begin this webinar.
Well, thank you very much, Eric, and welcome everyone. So I'm Sylvia De Sousa, a partner at TDS Law, and I've been practicing in the intellectual property technology field for almost 30 years. I use abbreviations, but I always try to explain what abbreviations mean before I use them. So I'll be using the word IP a lot, and as many of you know, that stands for intellectual property. The story that I give to clients of mine and even to young lawyers that work with me is when I started out many moons ago, it was hard to convince people to spend money even on a trademark filing, let alone a patent filing. And I think at that time, it was because there was not the education or the knowledge of what IP was. And now I think there's been a lot of education, and we're going to talk about the ElevateIP program, which does a lot of that. And there's also been a lot of assistance from government, and that's and the ElevateIP program is an example of that. But the big point that you need to take away is, and many of you already know this, business assets are changing. In the old days, when I started practicing, the key assets were physical assets, tangible assets, like buildings, like land, like inventory, like when computers were starting to be used. But currently, that's not the case. And now there's a lot of stats out there that are showing that the value of a business is within their intangible assets, and IP is an intangible asset. And so when you go into, I'm going to my first, hopefully I could get my first, give me a moment, I gotta get to my next slide here. On the first slide, my first point is value of IP as an asset and why having an IP strategy is important. And the reason why that's number one is because for most businesses, the value will be in their IP. But in order to be able to take that value and increase that value within your business, you have to be able to identify the IP and then protect that IP. And the way I describe it to my clients is there's 4 pillars in the intellectual property world, and this is how I see it. Pillar 1 is identifying the IP that's in your business. You all have IP, and we're going to be talking about examples of what types of IP exist. But the second pillar is protecting the IP. Now, you won't be able to protect all IP. You won't have the time or the money to be able to do that. But the pillar 2, protection of IP, is identifying the IP that you've got and then going the second step, which is what is the valuable IP in my business, and then protecting that. The third pillar is IP ownership. And I was just recently saying to one of my clients, when I do mergers and acquisitions, and I've done them for a long time in the course of my career, the reason some of these deals didn't go through, or the reason why they fell, It's not because a company didn't file a patent application. It's because they didn't lock up the IP ownership within the target company. And so that's why people, either lenders or prospective purchasers, would walk away. So IP ownership is a third pillar, and I think it's a critical pillar. And then the fourth pillar is monetization and commercialization. Ultimately, the reason why you're putting time and money into your IP is to be able to monetize, commercialize, create different income streams for your business, and make some money. And how do you do that? And we'll talk about that on pillar number 4. So for value of IP, the two examples that I like to give to sort of bring it home is we all know Google. Google is a trademark. Trademark is a type of IP. And Google, that trademark is worth, I think, approximately $33 billion. It's in the billions. And I think last time I checked, it was $33 billion. That's a lot of money for a trademark. The other example that I give is a client of mine many years ago sold, and a big multinational came into Manitoba and bought them. And they got a lot of money, in the millions. And so what did they get millions for? And it was a medium-sized business, not a multinational, not a small business, but a medium size. And they were in business for about 15 to 17 years. And what did they get their money, their millions for? All IP, basically. And the reason why they were able to get the value out of their business was because over the course of the life of that company, they protected their valuable IP. They locked up IP ownership. And so when that multinational came to buy them, they had all of that in place, and there were very, very, very little deficiencies when the multinational prospective purchaser, actual purchaser later, did their due diligence. So what am I talking about when I say IP? And that's item number 2 on this slide. There's different types of IP. And on this slide, I've given you the most common types: trademarks, patents. So trademarks would protect a logo, a design. Everyone on this call will have a trademark. If you're using a word or a design, a logo to sell a good or a service, you automatically get common law trademark rights. You don't have to go register somewhere to get a trademark. The minute you start using a word or a logo to sell a good or service, you automatically get that created by the law. So you all have it if you're selling a good or a service. Patents. Patents protect inventions. And in order to be able to get a patent, you do have to file an application. So doing something without filing will never create a patent for you. But in order to get that, you've got to file. Industrial design and patents protect inventions, machines, composition, processes, improvements on stuff that's already out there that you've come up with an improvement for. Third type is industrial design. So industrial designs protect the aesthetics of an item. So a good example are user interfaces. So the Apple phone, for example, I use that as an example with my clients. Apple has industrial designs on the look of an Apple phone, on that shape that goes like this, on the icons that show up when you click in. That's industrial design. Another example that I use for industrial design is a 3-legged chair, the look of a 3-legged chair. You get an industrial design to protect that. Copyright is another example of IP, and a good example of a copyrightable work would be software code. It could also be your design of your logo, for example, a manual, videos, photographs. Another type of IP is trade secrets. Trade secrets is confidential information that you've got in your business that gives you a competitive advantage over your competitors. Information you do not want anybody to know because it gives you that competitive advantage. That's a trade secret. Recipes, formulas, a process that you've got within your business. Source code are all examples of trade secrets. Domain names and social media handles, that's IP. And so the advice that I give clients there is you don't even need a lawyer for those 2 items. You just need time and a little bit of money because it's not expensive to register domain names. And so the advice I give there is lock it up. Get your domain name endings, the key ones, the .com, the .ca, the .org, the .net. And now any industry ending that applies to your industry, to your market, to your business, see if that exists and lock it up. Even if you're not using it, that's okay. Just lock them up so no one else gets it. I mean, the example that I've got is last year, I had 3 domain name disputes. 3 clients of mine called me saying, you won't believe this, but one of my competitors has taken a domain name that has my trademark in it, and they're diverting traffic from my website to theirs. Sylvia, you got to do something. Take that. I want that domain name. We were successful in all 3 of them, but you know what? They had to pay me to be successful, thousands of dollars to do that. Whereas if they had just locked it up, it would have been a few $100s. Social media handles. Lock up the key social media platforms. There's no fees on that. You just got to get your user and your social media handle. And you may say to me, but I'm not going to be on TikTok. You may not be on TikTok today, but who knows? Maybe 3 years from now, you're going to be on TikTok. And so when you go to get TikTok and get your social media handle, which they'll probably have your trademark in it, guess what? Someone may have gone ahead of you. And it's first come, first serve in a lot of these domain name social media handle cases. And it's not easy to win back that if someone else has taken away from you. So lock it up and just go and do it for social media handles. It's just time, right? Just give yourself 30 minutes, maybe on the weekend, and just figure out the key ones that are applicable to your business, and just lock them up. And then data. Data is IP. It's someone had said this, and I'm repeating it because I believe it. Data is the new oil. Here's a way that you can monetize and bring in a new income revenue stream for your business, but you've got to do it properly. And we're seeing with ChatGPT and other AI platforms that are not doing it properly. And when you don't do it properly, you're going to get sued. And so the way I describe data to my clients is, if you're not the owner of the data and you're not the user or a licensee, same thing, of the data, then you're an infringer. And if you're an infringer, you're going to get sued. So you got to make sure that if you are using data that your users are giving you, that you've got the right to do it. And now you're going to be the owner of that data, or you're going to be a user. Those are where the rights come. And if you're not either, you're going to have a problem. So those are examples of types of IP. Other examples that I have not listed there, they're not as common, would be integrated circuit topography for semiconductors. The other example is plant breeder registrations. If you're doing seeds, for example, or plants or varieties, so that's where the cannabis industry would come in. So these are examples of types of IP. So what I tell my clients is, I've given you sort of a snapshot. Jot down what you think you have in your business, and that would be column 1. So examples of trademarks that you've got, examples of inventions that you've got, designs that you've got, copyrightable works that you've got within your business. Jot down in column 1. And then column 2 is it valuable to you? Is it valuable to your business? And then just put a yes or no beside each item that you've got in column 1. And then column number 3, we'll go into the next slide. If I get there, is pillar 2, which is the IP protection. And that's column 3 in that table that you're creating. And IP protection is on the IP that you've identified as being valuable. That's the IP that you want to protect. And all IP is national in scope. No such thing as international trademark or patent or industrial design or copyrightable work. You do have to figure out what countries you're going to be making money in. Where am I going to make my money? And that's where you're going to be filing for IP protection. And so for that third column on your chart, if valuable, where am I protecting? And that's where you're going to list out the countries for each item that's on your row number 1, or sorry, column number 1. Which countries am I going to file for protection? And we work with clients on helping them identify the valuable IP and then helping them figure out what countries they should be protecting their valuable IP. And the way to protect trademarks, now you've heard me say that the minute you start using a word or a logo, for example, to sell a good or service, you automatically get common law rights. But on the key trademarks that you've got in your business, what I call house marks, and it may be just 1 or 2 of them. You might be just looking at 2 house marks, and everything else will be a submark. Like a tagline could be a submark, not a critical house mark. Then you ask on the critical house marks, you ask yourself, okay, these are important to me, and then you should consider trademark registration. And you may be thinking, but Sylvia, you just told me that I've already got common law trademarks. Why would I want to spend money and get a registered trademark? For 2 reasons. The Trademarks Act protects registered trademarks, and they give you 2 advantages. The first one is a monopoly across Canada to use your trademark after the registration date. Why is that important? Because you may start your business in Manitoba, but it may take you 5 years to expand across Canada. So it may take you 5 years, for example, to get into PEI, Prince Edward Island. And when you get into Prince Edward Island, if you have a registered trademark and someone's already there using your trademark and they started using after your registration date, you could knock on their door and say, listen, I'm coming in. I've got a registered trademark. You've got to stop. And they do. However, if you go into Prince Edward Island 5 years from now with a common law trademark and someone's already there using your trademark, and you won't be able to knock on their door and tell them to stop because they've got common law rights in Prince Edward Island if they haven't registered. And so now, and they take predominance with a common law trademark because a common law trademark only gives you dominance in the jurisdiction where you've started using it, where you're known. And so they'll be known in PI, so they dominate there. You may dominate in Manitoba. And the other big advantage with the registered trademark that comes from the Trademarks Act is if someone is stealing your trademark and there's an infringement, you'll get more rights from the Trademarks Act versus if you have a common law right, trademark right. With common law trademarks, you've got to use the passing off action, which is a very hard test to meet. So that's why on the critical trademarks, you should really consider getting a registered trademark. Patents, again, the only way of protecting patents is you've got to file a patent application. Industrial design, to protect those designs, you have to file an industrial design application. Copyright, different. So it's almost like trademarks. Copyright, the moment you create a copyrightable work that's tangible, original, by a Canadian citizen, you automatically get copyright protection. You don't have to file at the Copyright Office to get a certificate to get protection. The minute you create something that's original and fixed, you get protection. And the original component doesn't have to be a Van Gogh style or level. It could be a Sylvia D'Souza stick person on her iPad design. So it's not a high standard to get the originality. But I do tell my clients, listen, yeah, you do got copyright protection because you've created this beautiful software code. But if that software code, which usually it is critical to your business, you should look at copyright registration. It's cheap. The government fee is very inexpensive. And I usually tell my clients, you don't even need me to do that for you. It's a very simple application in Canada, one pager, you fill it out, you file it online, within 2 weeks, you get a copyright certificate. And the reason why you would do that is because it gives you additional protection in situations where someone is stealing your copyrightable works. And so for $65, I would spend that on my key copyrightable work assets to get that additional protection in case someone steals my copyrightable works. Trade secrets is another key component. And the only way of protecting trade secrets currently in Canada is the way I describe it to my clients. There's two ways. There's the business way and the legal way. On the legal way, the only way of protecting trade secrets currently is making sure that you've got agreements signed by people that you're disclosing your trade secrets to. A good example of that is a non-disclosure agreement. Another good example would be an employment agreement or an independent contractor agreement that have a confidentiality section in those agreements. Because if you don't have a confidentiality section, then you're not protecting your trade secrets. And then the business way of protecting trade secrets is, for example, on businesses that have software encryption, need to know access. For a manufacturing plant, you have people that are walking in, they're signing in. You know, we've all done that. We've walked into businesses where they've made us sign in, time out. Other businesses make you do that and they have a little visitor tag that's clipped to your shirt. So when you're walking around, people know that if people that work there, if they see people in certain restricted areas, that they're able to move people out of there because there's trade secrets within those restricted areas, usually processes, for example. And then domain name and social media. Domain name, you don't need a lawyer for that. You get a domain name registrar, get those domain names registered. Social media, you do that on your own time. Go onto the social media platform and sign up. So that's the pillar 2, intellectual property protection. And so for your third column in that chart, You're going to identify, what do I need to protect? What's valuable that I need to protect? And then on this one is, on this slide, I wanted to say non-disclosure agreements are critical because it ties into number 5 on that slide, which is the disclosure issue. And so the disclosure issue applies to patents and industrial designs. And the point that I want to make there is, if you tell someone how your invention works, how your process works, for example, how your machine works, or if you show someone your user interface design, and there's no confidentiality obligation tied to that disclosure, you may have lost the ability in most countries of the world to get patent protection and industrial design protection. And you heard me say, if there was no confidentiality obligation tied to that disclosure. If you've told someone how your invention works or what your design looks like, but they signed a non-disclosure agreement, that's a confidentiality obligation. So then that's not a disclosure, and you could still get patent protection, industrial design protection. And so that's why non-disclosure agreements, confidentiality agreements, same thing, become important, because you want them signed first before you tell people how your invention works, how your process works, what your design, user interface design or graphics design looks like. And that way, then you still have protection. You could still file if you decide that it's valuable to your business. I also have website, terms of use, and privacy policy. Those are critical documents. ElevateIP will help you with that, but there's also another program called the Digital Initiative of Manitoba program that's being run by the Manitoba Chambers of Commerce. And so at the end of my presentation, I'm going to ask you to look at both of those programs. And under the DMI program, you will get one of these documents for free, prepared by a lawyer. And so you should sign up. And I'm an approved service provider for the DMI program. Sign up, and they have people that work at the Manitoba Chamber that's going to be working with you to try to figure out if you qualify. And if you qualify, then they'll set you up with a service provider like myself, and then we'll figure out what's critical for your business, terms of use, privacy policy. The third document is a EULA that also comes under the DMI program, and you could get one of those documents for free. So if you don't have these documents on your website, I would highly recommend that you get it. And the DMI and the Elevate programs will help you with that. And then the 7th point that I've got there is open source code as it relates to software. And the point that I want to make there is, if you are developing, creating software within your business, I suspect that most of you are using open source code within that development. And I'm not here to say, don't do that. I actually love open source code. I believe in the premise, which is it's efficient and it's like a copy and paste. You're not reinventing the wheel. And I love being efficient, and I love getting projects done on time, keeping things moving. And open source code does that for you. However, there's risk if you're not careful, if you use open source code within your business. And the way I describe it to my clients is, there's 2 ways of handling intellectual property. You're either an owner of IP or you're a user. And with open source code, you're not the owner. There's someone else that owns that code, and they're giving you the right to use. So you're going to be a user. And the legal word for user is a licensee. And so when you get to use open source code, normally what's going to happen is there's going to be a license agreement attached to that open source code. And the minute that you start using it, you're going to be deemed to accept the terms, the license terms of that open source code. And the risk is as follows. And this is how I describe it to my clients. There's basically 2 types of open source code licenses. There's the permissive, which I'm fine with normally. And then there's the copyleft licenses. And in both situations, I tell my clients, when you're using open source code, always read the license terms. And the reason why is, if you want to see what kind of type of license you're using. Permissive, usually there's no problems. You're able to commercialize your proprietary code and go into the market and have end users, etc. But some open source code has a copyleft license attached to it. And some copyleft licenses state the minute you attach the open source code that has certain copyleft licenses to your customary proprietary code, the minute you do that, the whole project has to now be disclosed to the public. And so the value that you had on your proprietary gets down to zippo. And so you don't want that to be happening. And so I flagged this for clients because most people do use open source. Again, it's fine, but just make sure that you're reading the license terms. And if it's a copyleft that does what I just described, that will then make the value of your proprietary code to be zero, then you don't want to be using that open source code. You got to find another solution. So now let's go to pillar 3, which is IP ownership. And when you're creating intellectual property, the way I describe it to my clients is there's one of two hats that you could be wearing. You could be wearing an employee hat or a contractor hat. That's basically it. You're either an employee creating IP or you're a contractor creating IP. So it's not complex, but you want to lock up the IP ownership of your employees and of your contractors. And you do that by having an employment agreement with IP clauses and an independent contractor agreement with IP clauses. And you're saying, well, why is she putting with IP clauses at the end of each of those agreements? Because one of the things that I do for clients is high-level reviews of the documents that they use in their business. And the ElevateIP program will give you funds, grant monies to pay me to do that for you. And so we do a lot of that work. And you'd be surprised when we do a high-level review of the IP clauses in these two types of agreements that businesses are using within their business. You'd be surprised there's nothing or very little on IP. And so you want to make sure you have the right agreements with the right clauses in order to lock up the IP ownership. And so for employment agreements and independent contract agreements, the two key clauses for me is the confidentiality clause. You now know why that's critical because of the disclosure issue, and the intellectual property, which basically gives ownership to the company of all IP that's being created. Employment, you may be thinking, but Sylvia, I'm paying my employees a salary. Of course, I should own all the IP. Not necessarily, not in all cases. There's gray area in there. It's not black and white. And so you may think you own it, but you don't. And on the contractor side, I don't care that you've paid a software developer $100,000 to develop proprietary code for you. If you have not talked about IP ownership, you, the company, will not own that IP. So you've got to lock it up. And I don't like verbal because it comes down to a fight potentially on credibility issues. You'll say, yeah, no, you agreed that I would own all the IP on that code. Yeah, I know we didn't put it in writing, but you agreed. And the other person will say, no, I never agreed to that. So where's the evidence? And so you don't want to be there. You want to have written agreements with strong IP clauses that clearly state the company owns the IP. And now you may be thinking, but I haven't done that. And so that's called a deficiency. And so the ElevateIP program will help you deal with those deficiencies. And one of the agreements that I use a lot to correct deficiencies is the IP assignment agreement. And we have discussion with the clients, we figure out what the deficiencies are, and then we try to lock up the people that weren't locked up using IP assignments, for example. So that's pillar 3. The next pillar is pillar 4, which is the IP monetization and IP commercialization. And number 9 is examples of monetization, commercialization. So the normal situation is you're running your business and you're generating revenue. And how do I use what I've got within my business to do that? So that's the basic, that's what you're all doing. But other examples is purchase and sale of your business. So you want to make sure all the T's are crossed, all the I's are dotted on the IP side before you do a purchase and sale. Another way of monetizing is licensing IP to third parties. So having the right workforce or the sales force. And if you're a smaller business, you may have it for Winnipeg and for Canada, maybe even for the US. But you know there's a market in South America and Brazil. But you just don't have the time or the money to find and set that up in Brazil. Well, you may not have to. Maybe all you have to do is try to figure out who's the key player, who's the key distributor in Brazil, and then have a call with that person and just say, listen, I've got this IP, I've got these patents, I've got these industrial designs, I've got these trademarks, I've got the software code, the copyrightable with the copyright protection. And I know there's a market here. We've done that analysis. I'd like to enter into a license agreement with you, a distribution agreement with you, a distribution supply manufacturing agreement with you, or a supply agreement with you. And I'm going to license my IP to you to create my business in North America in Brazil. And then you pay me royalties. That's an income stream for you. Franchising is another example of monetization and commercialization. Data. If you are, the way I describe data to my clients is there's basically two types of data. There's the raw data that your users, if you have a software as a service platform, a SaaS, or if you have a mobile app, for example, that raw data that comes in from your users. Like I don't have my Apple Watch on me today, but you know that Apple's getting a bunch of data, raw data going into my Apple Watch. That's IP number one. And so usually my clients don't own that raw data. But that raw data is going into your platform. And then you're spouting out a useful type of data, a report, a trend chart, results that's readable, that's useful for either the user or for a third party, like an insurance company, like a financial company. And so that's where you monetize. But in order to be able, where you charge people for those reports, those trend charts, for those graphs, for example. So you're monetizing that. You're getting a royalty because you're allowing them to use it. But before you could do any of that, you will have to make sure that you're the owner or the user of the raw data and also the results, reports, graphs data. Don't assume that you are. And that's where ChatGPT is in trouble because they've sucked up all this data into their platform, into their algorithms, but they forgot to get permission from people who own that raw data. So they're not owners, they're not users because they didn't get the permission, so they're infringers. So you got to be very careful on that. And so how do you do that? And user license agreement is what I use to try to get my clients permission or ownership of that data. So that's the end user. Distribution agreements is another example of an agreement where there's licensing language within them, right? And so these are master services agreement is another example of a way of monetizing and commercializing. So where there's a bunch of license language in there, and those are bigger deals that we work on. So that's an example of monetization, commercialization. And then I've got on that PowerPoint slide, shred credits. If you don't know about shred, if you do and haven't applied, that's another item that you should look at. And for some of my startup clients, in order to meet payroll, they would be able to meet payroll because of the monies they would get through these shred credits. So if you don't know about it, go in, check it out. You could work with an accountant on that. And there's accounting firms that will do work on this for you on a commission-based basis. So if they don't get you monies, you don't have to pay them. And if they do get you monies, you'll give them a commission, a certain percentage that they'll take home, and then you take the rest. So don't leave that on the table. I would certainly look at that as another way of bringing monies into your business. And so you're now thinking, wow, that's a lot, and wow, there's dollar signs attached to that maybe I don't have in my business. And so what I've told clients is, because I've done this for about 30 years, for about 27 years, I could have listed 2 programs, government programs, that were helping businesses with IP protection, but over a 27-year span. Over the last 3 years, there's now a number of programs, and ElevateIP is one of those programs, and the DMI program is another example. And a third program is the IP Assist program through IRAP. So those 3 programs I would encourage all of you to look at. On this slide, I've got the ElevateIP program criteria. IP, as you know, is national in scope. this program will help you protect IP not only in Canada, but let's say your key market is also the US. They'll help you protect IP in the US. Deadlines in IP can be critical. And for some of this, you don't have all the time in the world. And so you do want to go and get the protection. And ElevateIP will give you access to grant monies up to $100,000 to be able to do everything that I've just described to you. Pillar 1, Pillar 2, Pillar 3, and Pillar 4, and in the countries that are critical to your business, not just Canada. And so on this slide, I've got the qualification criteria for the ElevateIP program. You have to be a startup. And when I say startup, I also mean businesses. So even a medium-sized business could qualify if you meet this criteria. Startup or a business that must be incorporated or registered in Manitoba or Saskatchewan. Startup or a business that must be less than 15 years old. Startup or a business that has fewer than 500 full-time employees. Startup or a business that must have under 10 million in annual revenue. So if you satisfy those 4 points, then I would highly encourage you to go on to northforge.ca and do an application and apply for this program. It's quick, it's not very bureaucratic, and I think it's a phenomenal program that will get you where you need to go on the IP front. And now you may be thinking, like, why within the last 3 years has government started pouring money into IP? And the reason is, as I said earlier on, there are now stats showing that the value in businesses is not tangible assets. It's intangible. Canada lags behind some of the key countries of this world. And we shouldn't be, because we're an industrialized country, but we do lag. And because the value, and it's going to keep going up, is in IP and intangible, this is going to weaken the Canadian economy. And so governments realize that, and they want to help businesses protect their IP to increase the value of a business, which then allows our Canadian economy to get stronger. Thank you very much. So I'm open now to questions. I'm going to see if I could do this properly. Okay, so I think now I have the video. I could see people's faces, which is great.
Yeah, so if anybody has questions, you can unmute or type it in the chat.
Hi, I have a question, Sylvia. It's regarding, you were talking about the IP Assist program.
Yes.
And you mentioned something, I think you said it was through OneRap. I'm just wondering if you can spell that.
Sorry, IRAP. IRAP. Another phenomenal program. There you have to have an IRAP advisor.
Okay.
So you got to apply to see if you qualify. So they also have criteria. And if you qualify, then you got to get set up with an IRAP advisor. And from my experience, those IRAP advisors, they're like rock stars. Like, they're so knowledgeable. Like, so if you don't have an advisory committee or an advisory board, that IRAP advisor could be that for you. Don't tell them I told you that, but I think they're just so bright, so helpful. But you need to apply, to qualify, and then land with one of these people, and then they have to recommend the IP Assist program to your business. So if you have an IRAP advisor, congratulations. Go back to them and say, listen, I've heard about this IP Assist program. Do I qualify? Because I'd love to look into it. And if you don't have an IRAP advisor, then you got to apply. ElevateIP, and I have clients that do both programs, because I've been approved for both programs. So I've got clients that do both. We start with the IP Assist, and then we go into into the Elevate, or we start with the Elevate, or we start with IP Assist, and we do a combination of both because they're both friends. It's yeah, you can certainly do that.
Wonderful. Thanks so much.
Thank you.
Kareem, I think Kareem has a question here. So he says, I have an idea that I believe is disruptive. I have not seen this business model software anywhere in the world. I'm not sure where to start to protect this. I'm looking into locking in the idea and then find angel investor to implement it. I do not know who to trust not to steal the idea.
Okay, so number one is, so I was saying to a client this morning, unfortunately, there's bad players out there. They're just, yes, you might not know, but you won't know who they are. Okay, so is it a big issue? No. Does it happen? Have I seen it? Yes. So I just treat bad players. So that's why I like everything in writing. I don't like this verbal thing because you just never know if you're doing a bad player. That's point one. Point two, if you've got an idea, apply to the ElevateIP program. Now, I think you need to have a corporation. So if you don't have one, but talk to them. Go to North Forge. Go talk to them because they're there to help people just like you with an idea like this. And they'll help you if you have to incorporate, they'll help you incorporate to get you to the next level. Or if they want to first talk to you about what to do next before you incorporate, they'll work with you on that. But ultimately, if you have an idea and you're afraid that someone's going to take it away from you, one of the ways you could protect that idea is to quickly go in and file a provisional patent application. You lock up the idea with a filing date by filing a provisional patent application. And it's good for 1 year, but it gives you 1 year to figure out what do you want to do. In this case, Karim, you're saying, I'm looking for angel investors. Well, you file your provisional, get your filing date, you've locked up the idea. Now you have 1 year to try to find those angel investors. And so if someone decides to steal your idea, the leverage that you've got to go after them is, I've got this provisional application. It was my idea. You see, it's been described here, and it was on this date. So I would start there. I hope I've answered your question. Another question?
I have a question, Sylvia. So I know you deal with lots of businesses and organizations. Like, what's the more recurring consequence of not having IP protection?
Yeah. So on the IP ownership issue, which is a big issue, because that's where you lose the value in your business if you want to sell, for example, or that's where the deals go away if you don't do it right. And so at least once a year, I get a call from a client or a prospective client, and the call goes like this: Sylvia, I use contractors in my business, and I've just seen my software code, or I've just seen my workshop manual being used by one of my competitors. My contractor went and copy and pasted some of this for a competitor. Like, you gotta go stop them, because that's my IP. This is my, and it's usually with manuals, like workshop manuals or for webinars, for some of those businesses, that's their bread and butter, that's their foundation. That's how they make their money. And my first question is there an agreement? No, there's no agreement, Sylvia. And my next question is, did you talk about IP ownership? What's IP? Or no, we didn't talk about it. And then I've got to give them the bad news and say, I think the contractor owns that IP. And therefore, he or she could go ahead and copy and paste it for a competitor or for himself or herself and do whatever he or she wants because they're the owner. That is example one. Another example is on the disclosure issue, where people have phenomenal ideas. And then they come to me because they hear about this patent concept. And they go, oh, I want a patent now, Sylvia. Well, that's good. What's your idea? And then before I even waste any money of my clients, I go, have you told anybody about this idea? And then they'll say, oh yeah, you go onto my website, Sylvia. Does this happen? Go onto my website. It's all there. I've explained it, And I go, when did you put that on your website? Because luckily, Canada and the United States understand people don't know the law. And they give people like you and I a 1 year grace period from the date of disclosure to get the application in, to get your patent rights protected. But Europe, no. Asia, no. Which are also big markets for some of my clients. And so then I go, so when did you put that on your website? I hope less than a year ago, because we have a disclosure for sure. But is it less than a year ago? Because then I could quickly go file. Oh no, so that's been on my site for 2 years. Sorry, no patent protection. So now we got to look at other types of IP and other strategies to try to keep the revenue going up before the copycats go in, right? So those are two big examples that people don't realize, and then they just lose value.
Right. Is there any other questions? Oh, yes, you can unmute, Abraham.
Hi, I
Hi.
would just like to say thank you for the presentation. Very well done. Lots of information within 30 minutes. It looked like a bit of a crash course.
Crash course. That's funny. Yeah, lots of information. I do teach the IP law class for the law school on IP, and so they do get a number of classes. But even then, I think they leave there with their eyes up like this because there's so much detail too.
Yeah, a lot definitely goes into IP for sure. It's a whole, it seems like a whole world of its own. Yeah. Yeah, thank you. So I was just listening to the other question earlier about the IRAP, and I just did a bit of a search. So it is with the National Research Council, the NRC.
Yes.
Okay, so
That's
it is.
Yeah.
Okay, so it's a federal program from the federal government. Okay.
Yeah. So both IP Assist and ElevateIP are federal programs. The DMI program was federal and now it's provincial. So it's now the province of Manitoba has taken it on with using the Manitoba Chambers of Commerce as their entity to try to find businesses like you who have needs, these digital document needs.
Okay. And these federal programs are mostly on. It's just that they probably have a cap, I assume, of how many projects or how many clients they want to take in, and they meet those numbers, I assume, and they have to. Do people get on like waiting lists, or is it just a first come, first serve, and
First come,
maybe
first serve. Yeah, it's not numbers. Like the ElevateIP, my understanding, it's not numbers, it's dollars. So I think there's been a bunch of money allocated to the ElevateIP program. It ends in 2026, but I wouldn't wait. Like I would do it right away, because as you know, programs sometimes come and go if the governments change, for example. And so my understanding it's dollars, and from my experience, on a different, not just IP programs, but generally on government programs, Manitoba does not punch its weight. We don't do it uptake enough. So that's why I've been doing all of these presentations. I want more Manitoba businesses to take advantage of this because we normally don't on these government programs. So please look at them, use them.
Okay, and I have not looked into all the criteria for these programs because I'm just hearing them for the first time today on this crash course. But do they give me a bit of an idea of how much funding they cover? Do they cover complete funding? There was one of them that had $100,000 available in funding. So do they cover up to that, or up to a certain percentage of the project, or how exactly do they balance it there?
Very good question. So there's 3 levels in the ElevateIP program: Tier 1, Tier 2, and Tier 3. Tier 1 is the educational level. There it's online education. So there's a bunch of resources that North Forge and Comatech and other players have created that's on North Forge's website. And so that's up to businesses to go and educate themselves. So they don't have an advisor like me educating them. ElevateIP, IP Assist has a level 1, and they do pay an IP professional like me to educate the client on IP, the crash course that you're talking about. They pay me to do that. But North Forge with the Elevate does not. You got to go do your thing. Okay. On ElevateIP on tier 2, they'll cover 100% of the cost up to $25,000. And for tier 2, you don't have to pay anything out of your pocket, but only tier 2 only covers an IP strategy report. So I work with clients to prepare a report on their IP needs. And so those 4 pillars that I described, that's how I structure my IP strategy report. And we do, and they're long reports. They have a lot of information because I do a really in-depth review of the IP in the business. It all goes into my report, and then I make recommendations based on our discussions, based on what I see, on what you need to do to identify the IP. I make recommendations on how to protect it, where to protect it, how to protect it. I then look at, I do high-level reviews of the agreements that you're currently using in your business. That goes into my IP strategy report. And then the 4th pillar is the commercialization, monetization. I try to give you ideas on how to monetize your IP. And so all of that goes into my report. You'll get that for free under tier 2 ElevateIP. You also get covered. Let's say I say to you, you know what? I think you've got an invention there. My recommendation is do a patent search to see if you could get a patent on this. So that's covered 100% by tier 2 for Elevate. Same thing with industrial design searches, same thing with trademark searches. I think this is your house mark. My recommendation is that you get a trademark registered. However, we should do a search to make sure there's no infringement or confusion. And so tier 2, they'll cover all of that 100%. Okay. Then you get this IP strategy report from me with recommendations. And then you go back to ElevateIP. Okay, Sylvie's made all of these recommendations. I want to protect my IP. I want to put these recommendations into place. That's tier 3. And there you will have to put some skin in the game. And that skin is either between 10 to 25%. I don't get involved in that. That's ElevateIP program. The people that run that, they'll tell you how much skin in the game you need to put in, but it's between 10 and 25%. But I work with my clients on, okay, I've made all these recommendations. You got access to a certain amount of X amount of money. I'm going to help you prioritize what we need to really focus on. And then I prepare a scope of work. And then that gets approved by Elevate. And then we start putting everything into place. And so, okay. But they cover the bulk of those costs.
Okay, thank you. When you say skin in the game, what are you referring to? Setting, you say setting, you have to put a certain skin in the game. What do you mean?
You got to put some money in the game. So, okay. So but not tier 2, tier 3.
Okay.
You got to put some money of your own money in.
Okay. Thank you very much.
Thank you.
Yeah.
Okay, so I think there's some questions in here.
We have another question from Sean D. You have your hand up. You can unmute.
Hi, thanks, Ms. De Silva, for the presentation. It's informative. My question is about the conditional patent, I think you called it. What's required for that? And do we do that under the program, or can we do it like right now? I think you said filing a conditional patent or something.
Yeah. So it's a provisional patent application. In order to be able to get the cost of doing a provisional patent application covered by the program, you have to apply, be approved. If you incur the cost before approval, you will not get reimbursed. So you got to be very careful on timing. That's why I'm really encouraging everybody here, just get the application in, right? I mean, even if I tell my daughters, if you don't do it, the opportunity is not there. If you do it and you get approved, it doesn't mean you have to do anything, but at least you've been approved, right? And then if there's a timing issue, like I had a client this week, where there's a due date of March 21. Because if we don't file by March 21, she's not going to get industrial design protection. So thank God she was approved for the ElevateIP program. They've made an exception because the IP strategy report's not done. And so they've made an exception where just for those 2 filings, the industrial design applications, they've approved under a tier 3 without even the IP strategy report. They're very flexible. They're also rock stars. And so now we're going to get those applications to protect those rights done right away, but don't incur costs until you get approved. And so, and if you want to file provisional without approval because you're really scared and there's some urgency there, and that could certainly happen, then in order to be able to, for me to do a provisional patent application, what I need to do is I need to get from you, if there's designs, I'd like to see the designs, and then I need a description of your invention. And then from there, we prepare the provisional patent application and we get it filed. And the good thing about a provisional, it's quick, it's cheaper than a full patent application. And I don't need, it doesn't have to be refined. On a full patent application, you have to be very careful in the wording and the drafting of the claims. On a provisional, it doesn't be as refined. It's just getting it in. And there's basically 2 types, the way I describe to my clients, of patents. There's the provisional and there's the full patent application, or the non-provisional. And the reason why this one exists is because the provisional, the con, is it's only good for a year. And then as that expiry due date is coming, you have to make a decision. Am I going to let it die? Or am I going to protect this invention by filing a full patent application? Does that make sense?
Thank you.
And again, thank you, Sylvia, for the informative session. I think it's something that people don't consider and should consider, obviously, because there's a lot of factor that goes into IP protection. And again, thanks everyone for joining this webinar, and I hope you guys all have a good afternoon. And again, if you guys have any follow-up questions, feel free to reach out to me or Sylvia, and we'll be happy to answer your questions.
Thanks very much.